Welcome everybody to Charity Chats. I'm joined once again by the lovely Catherine Rustomji from Shakespeare Martineau and James Saunders from Moore Kingston Smith. Today, guys, I'd like to talk about the latest judgment that came out that was described as a momentous new judgment, where we've got two charities, the Ashton Trust and Mark Leonard Trust, which were looking for the blessing from the court to adopt an investment policy that excluded, as far as possible, investments that weren't aligned with the Paris Agreement on climate change. Catherine, I'm sure you've looked at it from a legal point of view. What are your views on this?
Anything that's described as momentous decision, of course, it gets my interest. Had a look and was quite underwhelmed. I just was not sure that it does have this blanket application to all charities such that it would mean it is such a momentous decision. Part of the issue is around adopting an ethical investment policy, but for two charities who have environmental charitable objects. So it's unique to the facts in that respect that, yes, charities with environmental aims may well want to adopt an environmentally sustainable investment policy, but that doesn't mean that charities with completely different charitable objects would necessarily want to or should adopt any sort of revision to their investment policy based on environmental concerns, because that's not the cause of their charity's aims. And what it made me think of was, in years gone by, when we had hallmarks of an effective charity, the Charity Commission added to it at one time that charities need to have regard to the impact they have on the environment. And now we have the Charity Governance Code, and that talks about the board recognises its broader responsibilities towards the environment. And I think there's a big difference between recognising your place in the world and your kind of overarching general responsibilities, rather than then having this positive obligation and onus. And I just have my doubts about whether this will be a complete rewrite of the Charity Commission's guidance and whether the principles will change so massively as a result of this case.
James, have you got any thoughts on it?
Well, as neither a charity lawyer nor a charity investment manager, I kind of feel a bit of a dunce in this area, really. From a sort of a novice's point of view, if you like, it seems to me that there wasn't really anything new in this. It rather concerns me that the question of whether a charity can do ethical investment is actually really up for debate, because as far as I knew, charities have been doing this for some time. I understand the nuances of it, but it was a slightly surprising thing to read, really, that that there had to be this sort of court case to work through these matters, and furthermore to read through that. Firstly, more clarification, it seemed to be being recommended out of the judge's decision, and secondly, that the Charity Commission, I think, has now paused its updated guidance or its consultation on the updated guidance on responsible investment as well, while this is being considered. So it does seem that the Charity Commission considers it significant enough to start, looking again at some of the guidance it was trying to revise anyway. So I suppose in the end, it does seem to be we seem to be in a little bit of an uncertain position, with more clarification needed and more revisions to the guidance also on the horizon.
Yeah, I mean, it's funny, isn't it? Because I read the document, which I think was about 74 pages long. I'm being a slow reader, but I have to say I came away with it just thinking that the Bishop of Oxford case had still stood the test of time, and actually what comes out of the Bishop of Oxford case still seems to me very pragmatic. I mean, the judgment, to be fair, the judge did say this was very specific to the two charities, which have slightly unusual. I mean, it's not just environmental; it's also relief of poverty, which is which is sort of quite a sort of diverse
mix, isn't it? You wouldn't put the two together. No.
So he did say this judgment was very specific to them. I agree with you, James. I think that the law actually allowed them to do what they did. So there were a couple of interesting things came out. One is the Charity Commission raised a question about the cost of bringing the case. I said it would be quite interesting to know what that actually comes to. The other thing I think was interesting, that it was estimated, with all the restrictions that have been put in place, that they were going to exclude up to about 50% of the publicly quoted market and a reasonable number of the commercially available funds. But the trustees still expected that they would be able to deliver a return of sort of 4.5% net of fees, CPI plus 4.5% net of fees. And again, I think, well, that will be sort of tested over time, wouldn't it? But, you know, because you can make whatever claim you want, but actually you're going to be able to do it. I suppose you'd have to try and backdate that and challenge it. The other question, and this actually comes, I think, more from trustees, or the debate about whether you divest or whether you engage. And I think that is I think that's a much more interesting one. I'm hoping that the Charity Commission will not make a major change to their guidance. I don't think this judgment actually would encourage that.
No. I could see why they've paused it, because I think they did have their consultation, didn't they? And I suppose if it's a big case going through, it makes sense to wait and see what happens. But I'd be amazed if they had to rewrite much, if at all, of that guidance, because I would agree with you. I think the Bishop of Oxford case is still there, is still relevant, is still quite helpful, I think, in the points to consider. But I do think it is an interesting point that if your objects are about protection of the environment, then query, isn't it better for you to generate as much return as humanly possible and then use that greater amount of charitable resource to advance your charitable aims, rather than potentially reducing the amount that you can generate by return? I know that they've said they'd still get a healthy return, but it almost seems too good to be true that you could eliminate that much of the market and not be adversely affected as a result.
Yeah, and the other thing I think sort of has come out of this, isn't it, is making trustees just think a little bit more of a holistically across their whole organization and not just investment.
Yeah.
You know, so looking at their operations and what we're going through an exercise at the moment, part of our strategic review, in fact, for Glasspool, where we're looking at a sort of our carbon footprint within the office, you know, the suppliers we use, and also, you know, the organizations that we engage with, and what can we be doing to improve things, but on the basis that you know, progressively doing things is going to have a positive change rather than anything big and significant we can do.
Yeah.
And also that it shouldn't just apply to investments.
Yeah, that's true, isn't it? Because there's more to it than that.
Yeah, I mean, the couple of bits that I took away in general were the decision seemed to be talking about trustees still have discretion. It is still down to their discretion as to how they invest, all that sort of thing. And as long as they can document their decision-making process, they're probably on pretty safe ground, generally. I think there was a phrase or a clause about, you know, there's no specific embargo on certain things, because it does actually, in the end, come down to trustees' discretion and acting in the best interests of the charity, however that comes about. So as long as there is that thought process there, that, you know, I suppose really the Charity Commission is going to struggle to argue with a well thought out, well reasoned, well documented proposal of any sort. I suppose the other bit that I started thinking about after that was the big danger for trustees is that, one of the big dangers for trustees is that they bring personal moral considerations and moralities into the charity's decision-making process, and that's the big worry. And how do you take out the personal desire for moral decisions from the charities as an entity in its own right, and that final decision? Because that's the real worry for trustees, is that you're accused effectively of making personal decisions through the charity.
It's a really good point, isn't it? And I think that group decision of whether the charity has an ethical policy should be about what's in the charity's best interests, not about who shouts the loudest as a trustee. That, yes, we want trustees to have morals, but they don't get to impose those on their charity. It's got to be adopted by all of the trustees if they want that.
And who's to say that all of the trustees at any one time will have the same opinion as the trustees 5 years ago or 5 years in the future, and also of all the beneficiaries as well. If there are, any stakeholder in the charity, it's a difficult responsibility, I think, that one for trustees at any one time.
But if you remain focused on the charity's objectives and what purpose is, actually, that shouldn't be, I mean, don't get me wrong, these can be complex issues, but it shouldn't be a difficult thing to make a decision on. Because my biggest fear with this is that you'll get some people who are very evangelical and will be bullying trustees to do things that they really shouldn't do. And actually, the Bishop of Oxford case gives them, I think, a very robust legal framework that's really clearly written, and despite it being written in 1992, has still very much so stood the test of time. Because this court case, from my understanding, was brought because actually they didn't believe that the Bishop of Oxford case has stood the test of time, and things have moved on. And I'm not sure that came out of the judgment. I think the other thing, and just probably as a final thought, about this divest and engage, and although you can invest on either way, and I think each individual organisation needs to make its own decision. But actually, from a personal basis, I sit down on the engage side of it. Over the last 2 years, something like $60 billion worth of assets that are fossil fuel related have been bought up or snapped up by private equity. So effectively, you've moved from being in a very regulated, transparent marketplace into a slightly opaque area. And of course, so you're moving these assets into the shadows, in a place. But of course, who effectively funds private equity? Well, it's institutions, pension schemes, charities, private individuals, because they're the ones who provide the capital, but they've effectively lost their voice to influence how these assets are. Anyway, I think, yes, it'll be interesting to see what the guidance comes out. We've actually done a note on this, which gives a bit more detail. So Catherine and I have got together on that. So we'll put a sort of a link up on the on this recording. But thank you. I think an interesting debate.